Welcome to the first part of the lecture on civil litigation before the trial. Now, you'll recall that litigation, it refers to the process of working a lawsuit through the court system. But briefly here, I want to step back for an even broader view. Litigation actually begins with some event that gives rise to a legal dispute. It could be an accident, it could be a breach of contract. It's usually some event that involves causing harm to somebody or the threat of imminent harm that would prompt this injured person to file suit. So the litigation process actually begins with a legal dispute and then the filing of the complaint or petition that will initiate the lawsuit itself. Now, let's fast forward. The litigation process will run its course and it will end with a written document called a judgment. And this judgment will set forth the court's final written decision about the rights and claims of the parties to the lawsuit. Now, you must know that the vast majority of civil lawsuits settle before the case reaches trial or a final judgment. Now, a settlement is an out-of-court agreement between the parties regarding a resolution to their dispute so that the lawsuit does not need to continue. And if a full settlement of all of the disputes in the lawsuit occurs, then the court will normally dismiss the lawsuit without actually ruling on any of the issues because it's a moot issue now that the parties have settled. Dismissal is an order by the court terminating the lawsuit. One thing to remember, however, is despite the statistics of civil cases settling before trial, you cannot assume that your case is going to settle. If you're an attorney or a paralegal, until the case settles, you don't know for sure. And you need to be careful to prepare the case the way you should in case, for whatever reason, the case does not settle. You might be surprised. The parties might dig their heels in and the case does not settle. So you have to assume that the case is going to go to trial so that you're doing what you need to do to prepare for trial just in case the case does not settle. Settlement is not guaranteed to occur until it actually occurs. Now, litigation in the civil context is governed by procedural rules, and in federal courts nationwide, those rules are the Federal Rules of Civil Procedure, and they govern civil lawsuits in the United States District Courts. Those are the federal trial courts. Now, usually each United States District Court will have its own local rules that may modify or supplement the federal rules of civil procedure to some degree. Also, it's very common in federal courts that the individual federal judges will have their own specific requirements that will apply only to those lawsuits over which they preside. So there are three categories of rules you would need to consult whenever you're working on any federal trial court lawsuit. And that is the federal rules of civil procedure, the local rules of the particular U.S. District Court, and any specific requirements of the particular judge assigned to your case. Now, if you happen to be in a Texas trial court, you have roughly the same possibilities of rules that are govern how things work. In Texas, the courts, the district courts and the county courts in Texas are governed by the Texas Rules of Civil Procedure statewide. But each county within the state may have its own local rules that may modify or add to the Texas Rules of Civil Procedure. And in Texas, you may have some judges that have their own requirements for those cases that are filed in their courts. So again, you have three categories of rules, or at least potential requirements here, that you'll need to check for every civil trial court case that you're working on to make sure you have the full picture of all of the governing procedural rules. Now, this discussion of procedural rules uh, begs the question. We say procedural rules or procedural law. Well, what is not procedural law? What would be sort of its opposite? And that is substantive law. The important distinction to keep in mind is the difference between substantive law on the one hand and procedural law on the other hand. Substantive law governs the issues that the parties are going to be fighting about in the lawsuit. That is, their respective rights and obligations toward each other. So, for example, negligence law is a substantive law. If one party is claiming the other party was negligent, and such as driving, and caused the first party some kind of injury. Well, all of that law is substantive law because it governs what you're supposed to do when you drive and what would constitute not doing what you're supposed to do and so forth. Contract law is another substantive law. If you enter into an agreement with someone, substantive law governs when that agreement can be legally enforced in court and how to interpret the terms of the agreement if it's in writing and so forth. Anti-discrimination laws, another example of substantive law, the laws that prohibit businesses and other and governments and states and so forth from discriminating against people based on certain characteristics. Criminal laws are in part substantive laws. The criminal laws that define crimes are substantive laws. That is, that define what acts or omissions, if committed, would constitute an offense that is punishable if you're convicted. So that is a substantive law because it's defining those acts or omissions that we are not allowed to engage in. And if we do, we have violated the law. Now, procedural law, by contrast, governs the mechanics of the lawsuit itself and the court system. So, the rules of civil procedure govern how, if you do find yourself in a situation where your substantive rights have been violated, how do you go about filing a lawsuit to seek redress or to enforce your rights? And what is the judge's role? What categories of evidence can and cannot be admitted as a general proposition? And these are the evidence rules are another form of procedural laws that govern what types of evidence, what standards evidence has to meet to be admissible in a court of law and considered by a judge or jury when deciding disputes. Now, in criminal law, I mentioned part of criminal law is substantive, that is the law of crimes, but also there's a big body of procedural criminal law. And these are embodied in rules or codes of criminal procedure. And these regulate the actions of law enforcement and public prosecutors once a person has been suspected or accused of committing a crime. So this is the big difference. Substantive law defines the rights and obligations that people and entities have toward each other, whereas procedural law governs the mechanics of the legal system itself when someone is wanting to enforce a substantive law right or seek redress for a violation of that right. The rules that we're going to be talking about in this chapter are going to be primarily procedural law because they're going to govern what are the mechanics of a lawsuit from the time it is filed, at least for this chapter, up until the time of trial. A later chapter will deal with the procedural laws of the trial. Okay, I said I'm giving you a bird's eye view. I now want to give you a very short chronology of the main events in the pre-trial litigation process. So first, as I mentioned, there's going to be some dispute between the parties. Some event occurs that causes harm or a threat of imminent harm to one of the parties. and they can't work it out. So the aggrieved party will usually consult with an attorney at that point about the prospects of suing. And if the attorney concludes that, yes, this person has a good case, the attorney or the paralegal of the attorney may conduct a more extensive interview of the client to get more details or conduct a little bit of more investigation to get the information necessary to file the lawsuit. And if the attorney agrees to take the case and the client agrees to hire the attorney, then the attorney and client will both sign the retainer agreement, which is the agreement that will lay out the fee structure, the terms of the representation, the scope of the representation, and so forth. Now, as I mentioned, sometimes the firm will need to conduct some additional pre-suit investigation to make sure that the firm has enough facts to be able to prepare the first document that will be filed to initiate the lawsuit. And that document is called a complaint if you are in a federal trial court, or a petition if you're in a Texas trial court. And so the firm, the plaintiff's firm, will file the original complaint or the original petition with the clerk of the appropriate court on the client's behalf and pay a filing fee to do so. Now, once this complaint or petition has been filed, then it's up to the plaintiff's attorney's office to ensure that the defendant is properly notified that he, she, or it has been sued. And this is called service of process. That is the formal delivery of a copy of the petition or complaint that's been filed, along with a separate document called a summons in federal court or citation in Texas court that will inform the defendant expressly that the defendant has been sued. We'll tell the defendant how to calculate the deadline for filing the appropriate written response with the court clerk, and the attorney for the plaintiff, and everything like that. So that is these two documents combined, when formally delivered to the defendant in a way approved by law, constitutes service of process. That is formal notice that the defendant has been sued. And that's a huge due process requirement, that the defendant get proper notice of the suit so the defendant has the opportunity to appear and be heard. Now, once the defendant has received this notice through service of process, there are some alternative ways, but service of process is the usual method. Then the deadline starts to, clock starts to tick for the defendant to file a written response to the complaint or petition with the court. Now, we'll talk about the two options the defendant has in the next lecture, but usually that document is called an answer. And so that's simply the defendant's written response to the plaintiff's complaint or petition that the defendant files with the court clerk. And there's a strict deadline for filing that we'll look at later. Now, once the answer has been filed, then the lawsuit shifts into the discovery phase. And that's the phase of the lawsuit where the parties will exchange with each other and respond to requests from each other for relevant facts, information, and evidence about the case, so they can see what evidence, what information each other has. And it's a formal process, and the rules of procedure allow for 5 basic methods of discovery: interrogatories, requests for production, requests for physical or mental examination when there's a personal injury at issue in the case, requests for admission of facts, and depositions. Now, once discovery is completed or substantially complete, normally, if a party believes that the facts of the case that entitle that party to win once the law is applied, then that party can ask the court to right then enter judgment in that party's favor without going forward with a trial. This is called a motion for summary judgment. It's called summary because it would be entered without having to have a trial. We're going to look at this motion in more detail in the next lecture, but at this point in the case, again, once discovery has been completed or substantially complete, that's when the parties tend to have a good idea of what evidence is out there. And then if a party believes that there is no dispute about the key facts that when applied to the law cause that party to win, then that party can file a motion for summary judgment and see if the court will grant judgment then and there for that party. But let's now start with the filing of the lawsuit. Filing of the lawsuit involves filing a document called a complaint or petition by the attorney for the plaintiff. Now, I want to make sure you understand this category of documents that includes the complaint or petition, and it also includes the defendant's answer. These documents are called pleadings. They are the written statements by the plaintiff, that is the complaint or petition, and the defendant's answer, in which the parties respectively detail the facts, for the plaintiff, the causes of action against the defendant, and for the defendant, any defenses the defendant may be able to desire to assert in the litigation. So, as I mentioned, the plaintiff's pleading is called a complaint in federal court or petition in a Texas trial court, and it is the document the plaintiff files with the court clerk to initiate the lawsuit. And then the defendant's pleading is called the answer in both state and federal court. And so that is a written response to the complaint or petition. Now, this category of documents is called pleadings. And so if a document is not a complaint or a petition or an answer, it's not a pleading. These documents collectively will set the stage and will lay the framework for the legal and factual issues that have to be resolved in the lawsuit. And parties are normally allowed a limited opportunity in every lawsuit to either amend their original complaint or petition or answer, or to supplement it. And so any amended complaints, petitions, or answers, or supplemental complaints, petitions, or answers are also pleadings. But it has to be a complaint, petition, or answer, or some version thereof. Now, every jurisdiction's rules of procedure are going to govern and dictate what a plaintiff's complaint or petition must contain. Now, I'm going to give you a list here of some common elements that are pretty much universal, regardless of the jurisdiction. But again, just know that you would need to consult the procedural rules for the particular state, or if you're in federal court, the federal rules to make sure you've got everything covered. But here are the common contents. At the top of the first page is a caption in a standardized format governed by the particular jurisdiction that will identify the unique case number assigned to the case by the clerk, the names of the parties to the case, the plaintiff and the defendant, the identity of the court, and the title of the document. Now, also, there will normally be a very either first or second section of the petition will be just a description of the parties and where they reside. Most jurisdictions require, at least to some degree, that the plaintiff specify why the court has jurisdiction to hear the case. That is, the power or authority to hear this particular case. And as we'll recall, there's subject matter jurisdiction. There's also personal jurisdiction over the defendant himself or herself. And so usually courts require that subject matter jurisdiction be explained in the complaint or petition. Also, sometimes, depending on the circumstances, a plaintiff's attorney may want to plead the reasons why venue is proper in the particular county. If you're in, say, a Texas state court, why it's being filed in Collin County as opposed to Dallas County, or if you're in federal court, why the case is being filed and is proper in the U.S. District Court for the Eastern District of Texas, rather than the U.S. District Court for the Southern District of Texas. Complaints or petitions also contain a factual statement, that is, allegations regarding the parties' dispute, what happened between the parties that gave rise to their dispute. And then after laying out these basic facts, then the plaintiff will identify one or more causes of action that the plaintiff is asserting against the defendant. Now, cause of action, which could be translated reason for the lawsuit, is a legal theory recognized by the applicable law and supported by actual facts and evidence of this specific case that entitle the plaintiff to sue the defendant. We've already looked at some causes of action just in this lecture. Negligence is a tort cause of action. Breach of contract is a contract cause of action. And violation of an anti-discrimination law would be usually a statutory cause of action. So there are lots of different causes of action. And so in addition to alleging a summary of some key facts, the plaintiff will also allege the legal theory that these facts support and that the plaintiff claims entitle the plaintiff to sue the defendant and recover money from the defendant or whatever other remedy the plaintiff seeks. And the petition or complaint will normally contain a description of the damages or harm that the plaintiff has suffered as a result of the actions or omissions that the plaintiff is alleging against the defendant. And then toward the very end of the complaint or petition is a section called the prayer. And this is a formal request directly addressing the court, asking the court at the end of the day to impose a specified remedy against the defendant and in the plaintiff's favor. And in a civil case, normally that request is that the judge enter a judgment for money, a judgment holding the defendant liable for a certain amount of money to the plaintiff. Now I'm going to walk you through an example of a Texas court petition. This is, again, it's called a petition because it's in Texas court, not federal court. And there are going to be a few details in this petition that were not on the list of components I just walked through because they're peculiar to Texas practice. But let's start off with the top of the first page. Here we have the caption. Notice how it's laid out. This is the traditional way and the standard way that the caption is organized in Texas state courts. I might possibly exclude family cases, maybe probate cases, which might have their own. But in general, in most civil cases in Texas trial courts, this is the format of the caption. So let's walk through its components. Notice at the very top, we have the words cause and the abbreviation for number and a line that is a blank. The cause number, and it's sometimes called a case number or a docket number, because a docket can refer to all of the lawsuits that are pending in a particular court, is a number that is unique to the lawsuit and is assigned by the court clerk at the time the lawsuit is filed. Now, cause number comes from cause of action. And so that's been a traditional way to refer to this unique identifying number in Texas courts in any event. So this unique number, notice it's blank on this example because this is an original petition. It's been drafted, but for our purposes, it has not yet been filed. And you won't know what the cause number is until the time of filing, when either the court clerk or the online filing system assigns a cause number to it. So you leave it blank on an original petition for filing. But after that, you'll know what the number is, and that blank will then be typed in with the appropriate cause number for the rest of the case. Now, you have to remember that this is one of the key identifying parts of the lawsuit. And so if you're ever having to call a court clerk and ask for information or send a letter referring to a lawsuit, you always need to include the cause number or case number or docket number, because that's the key filing information that the clerk will need to be able to process your request or answer questions. So that's the cause number at the top. Now you'll see that the caption is divided into two halves, separated by a vertical line of these section symbols. The section symbols to create this vertical line in the middle is the typical way to do it. Some firms and courts, and instead of using section symbols, we'll use an open parenthesis under single parenthesis, one under the other instead of these symbols. But let's look first at the left-hand side of the caption. This is where you identify the parties. This is called the style of the case. That is Jerry Jones versus Robert Griffin Romo. You could also call it the case name. But the style of the case is simply the names of the parties. And sometimes you'll have multiple plaintiffs and or multiple defendants. And the style of the case will be organized in a way that where the parties' names are divided by side, and they will be separated by the lowercase letter v period, which stands for the Latin word versus, against. One tradition in the law is that in a style or case name, the little v is just a little v period. There is no s after the v, as there might be, say, in a boxing match. So you just want a little v whenever you are writing out the style of the case. And some styles will contain the designation of the parties. For example, here, Jerry Jones is the plaintiff. So that's the party designation. She is the plaintiff, and Robert Griffin Romo III is the defendant. Now let's look at the right-hand side of the caption. This is the court information. This identifies here 3 pieces of information about the court. The first line, where it says in the district court, refers to the type of court. That is, it's a Texas district court. And there are hundreds of district courts in the state, and they are a state level court. Now, the second piece of information in the middle is the venue. This is a district court that sits in Collin County, Texas. And then at the bottom line, we're told which district court in Collin County the particular court is. Larger counties like Collin and Dallas and Harris and so forth have multiple Texas district courts sitting in them, and they each have an identifying number from 1 sequentially all the way up to 400 or whatever. So if you're in that situation, as this example petition is, where you are filing in a large county with multiple district courts, then you won't know which of those district courts your case will be assigned to until you file the petition and the court clerk assigns your case to one of them. So that's why here you have to leave the blank for the judicial district number, that is the district court number, blank so that the court clerk or the filing system online can assign you that court. And then once you've filed the original petition and then you've had the court assigned, then from then on, you would need to have the court number filled in, such as 191st Judicial District. Also, this applies to county courts at law. There are bigger counties like Collin have multiple county courts at law. There's county court at law number 1, number 2, and so forth. Well, you won't know which of those county courts at law your case is assigned to until you have actually filed the petition and the county clerk has assigned you to one of the courts. Okay, so the last part of the caption is the document title, sometimes called the document designation. And so this is just, simply the title of the document, but most court documents that are filed with a court, by definition, will tell you 3 pieces of information. First, they'll tell you which party is filing this document. And in our title here, Plaintiff's Original Petition, we are told it is the plaintiff's petition as opposed to the defendant's document of some kind. The second piece of information is the version of the document. Here it's the original petition. That is, it's the very first petition that the plaintiff has filed in this lawsuit. And the third piece of information is the type of document. And here it's a petition as opposed to an answer or a motion. So normally your title of a court document will have these 3 pieces of information. Now, if you're filing a pleading, whether it's a petition, complaint, or answer, the first version filed by the party in the case is normally designated the original version, the original petition, the original complaint, the original answer. And then later, if that party files an amended version, it would be called the first amended petition, first amended complaint or answer. Or if the party files a supplemental version, which would just simply add to what has already been filed, it would be called the first supplemental answer, first supplemental petition. And if the party amended or supplemented again, then it would be the second amended complaint, second amended petition, second amended answer, and so forth. Now, so this is the caption of the case of the document. Now, the language right below it is very traditional. It's been around a long time, but it's not strictly necessary. The salutation is the language to the honorable judge of the court. Older forms will say to the honorable judge of said court, SAID, meaning previously identified court from the caption. And then the sentence below that is simply a preamble telling the court, I, the plaintiff, am filing this document. Now, there's nothing here in the salutation and preamble that we don't already get from the caption, which is one reason why it is technically not necessary. However, this language has been around a long time. Older form books still have it, and a lot of attorneys still use this language. So you'll want to make sure that you are using the style and approach that your supervising attorney prefers. Okay, now let's get into the substance of the petition. Roman numeral 1. This is peculiar to Texas. Texas has various discovery control plans that govern how extensive of discovery can take place in the lawsuit, how long it can last for, and that phase, and so forth. And so this lecture is not really designed to go into these details. You'll learn all about this in the civil litigation course. But in any event, in Texas practice, you have to designate a discovery control plan, and that's what this first paragraph does. Note that, first of all, the text of a pleading is double spaced. That will be true of virtually every court document you file. Also, the paragraphs are numbered. The Texas Rules of Civil Procedure require it, so do the federal rules. And that's so that later, if in motions or in court hearings, if a party needs to refer to a particular statement in the pleading, it can be easily identified by paragraph number. So Roman numeral 1 is discovery control plan. Now below that, we have our descriptions of the parties. Plaintiff Jerry Jones residing in Collin County, and Robert Griffin Romo is an individual residing in Collin County, but notice the extra language for the defendant, who may be served with process at his residence address, and then the address follows. The reason for adding the street address is so that whoever delivers the suit papers to the defendant will know where to go. And so that's why you have that extra information there. In the parties section, you will have one paragraph per party that you're describing. Okay, here's number 3. This is the statement of the bases for the court's jurisdiction. Notice here paragraph 4 describes why the court has subject matter jurisdiction. And remember that subject matter jurisdiction is the court's power or authority to hear a particular type of case. And in text, this statement is required under the rules of civil procedure. And here it's just telling the court that the amount of money the plaintiff is seeking in this case exceeds the minimum amount the plaintiff would have to ask for this court to be able to hear the case. In other words, the case is not too small. Now, the next sentence is another quirk in Texas pleading practice. It's required under the rules of civil procedure in Texas about a sort of a range of money that the plaintiff is seeking. And so, again, you'll learn more about that in your civil litigation course. Now, the 5th paragraph is referring not to subject matter jurisdiction, but to personal jurisdiction. That is the court's power or authority to be able to adjudicate the rights of or obligations of the defendant himself or herself or itself. And here, the plaintiff is simply saying the defendant is a resident of Texas, that is, of the state where the court sits. And you may recall that a court will always have personal jurisdiction over a resident of the state in which the court sits, as long as that person receives proper notice of the lawsuit. So we've got our jurisdictional allegations here. Usually personal jurisdiction allegations are optional, but subject matter jurisdiction statements are required. Now look at Roman numeral 4, venue. Now, as a reminder, venue refers not to jurisdiction, but to the locality within a particular state where the lawsuit is filed. And some localities are going to be proper and some won't. It's all governed by the applicable venue statute. And so here the plaintiff has pleaded that provision of the Texas venue statute, which is in the Texas Civil Practice and Remedies Code, for the basis for suing in Collin County. And it's because all or a substantial part of the events or omissions that have given rise to the plaintiff's cause of action, as we'll see, it was a car accident, occurred in Collin County. And that is one of the bases provided in the venue statute for venue to be proper in a particular county. All right, next section, Roman numeral 5. Here we have the facts section. The facts section is going to contain just enough background and detail so that the defendant, when receiving this petition, will have fair notice of why the defendant is being sued. The plaintiff does not have to plead every fact that the plaintiff has. The plaintiff doesn't have to marshal all of the evidence and describe it in the petition, at least in Texas, and that's also true in federal court. Some other states have different standards, but in Texas and federal court, it's simply a fair notice standard, or that's why it's called sometimes the notice pleading standard. So in paragraph 7, we're told that the lawsuit arises out of an auto accident occurring on February 2nd, 2020 in Plano and Collin County. And we learn that the plaintiff was driving her vehicle at the 2300 block of Spring Creek Parkway when the defendant, Romo, while driving his vehicle behind hers, failed to keep a proper lookout, failed to apply his brakes in a timely manner, and failed to maintain proper control of his vehicle. And as a result, his vehicle collided with hers. So that just gives us a basic idea of the event, of the incident, of the circumstances that gave rise to the need for this lawsuit. Now look at the next section, Roman numeral 6. Cause of action is negligence. Remember, the cause of action is the recognized legal theory supported by the facts that under the law entitle the plaintiff to sue this defendant and recover if the plaintiff can prove it. So paragraph 8 says that incorporates by reference that says basically the facts stated in paragraph 7, well, they are supporting the legal theory I'm laying out now. And so the plaintiff alleges that while driving his vehicle, Romo had a duty under Texas law to exercise that degree of care that a person of ordinary prudence would have exercised under the same or similar circumstance, and that Romo breached this duty, and that this breach or violation of the duty proximately caused damages to Jones, for which she hereby sues. So these are the legal standards, the elements of a negligence case: duty, breach of duty, proximate cause, and actual damages. And so combined, the facts in Roman numeral 5 and the legal theories laid out in Roman numeral 6 are together the description of a cause of action in its fullness, facts and legal theory. Now here in Roman numeral 7, we have the description of the damages that Jones claims to have sustained as a result of the negligence of Romo. So she alleges she incurred medical expenses in the past and that in reasonable probability will incur them in the future. Also, in paragraph 10, that she sustained pain and suffering in the past and in reasonable probability will do so in the future. And finally, in paragraph 11, she alleges that she lost wages in the past as a result of his negligence. So that's the harm that she claims she sustained as a result of his wrongdoing. Now notice here in the next section, Roman numeral 8 is the jury demand. For a party to be entitled, if the case goes to trial, to have the fact finder be a jury instead of just the judge, then that party has to make a timely written request with the court for a jury, for the case to be a jury case, or this is a jury demand. And you have to also pay a relatively small fee to the court. It's called a jury fee. But if you do that, then the case gets put on the jury docket. And if it goes to trial, then the fact finder will be a jury instead of the judge. So it's very common in petitions or complaints, if the plaintiff wants this to be a jury trial, if it goes to trial eventually, then the plaintiff will include a short one-sentence statement demanding a jury in the case. And that would also require that the court clerk be paid the jury fee. Now this next section, Roman numeral 9, says conditions precedent. Now in Texas state court, this is a standard statement by the plaintiff, basically saying that if the plaintiff had been required to do anything as a prerequisite to filing this lawsuit, or if any conditions had to exist as a prerequisite for filing this lawsuit, those have occurred or been done. And for example, sometimes if you want to sue under a certain statute, the statute will require that before suing, you have to give written notice of your complaint or claim to the opposing party a certain number of days or months ahead of time before you file your lawsuit. So this standard conditions precedent statement is simply saying everything, if anything, that we had to do or that had to have occurred before we file this lawsuit has been done or has occurred. And then it's up to the defendant. If the defendant believes that there's something that should have occurred that didn't, then the defendant will have to specifically deny this in the answer. Okay, well, that brings us to the last of the substance of the petition, and that is the prayer, Roman numeral 10. And so again, this is the where the plaintiff directly speaks to the court and requests the court ultimately to do something in the plaintiff's favor and against the defendant. And so here, Jones is asking the court, first of all, to issue citation, which would be then served on Romo with the petition. We'll talk about service of process in a second. And then Jones wants the court to issue a judgment against Romo for actual damages, pre-judgment and post-judgment interest, court costs, and all other relief to which Jones is entitled. So actual damages would mean the elements of damages that she outlined previously: past and future medical expenses, past and future pain and suffering damages, and finally, past lost wages. Now, pre-judgment and post-judgment interest is actually provided by the Texas Tax Code, and it allows a plaintiff who wins a money judgment in court to include in that judgment interest on the amount of the damages that the defendant has been adjudged liable to pay leading up to the day before the judgment is signed. It's as if it's treated as if the defendant had owed this all along. And so that amount is added into the judgment in a specific dollars and cents amount. Post-judgment interest is interest on the judgment once it is signed on the total amount of the judgment. That interest accrues on that amount until the defendant pays the judgment. So it's an incentive for defendants to pay judgments quickly and not drag it out. And so the pleading for pre-judgment and post-judgment interest is very, very common. It's in almost every civil complaint or petition that seeks any kind of money. Now, this third element of the prayer is court costs. Those are litigation-related expenses, and they're laid out by law that the prevailing party, the winning party in the lawsuit, is entitled to recover reimbursement from the other party. Even if it's the plaintiff who wins, then these expenses such as filing fees, service of process fees, deposition, court reporter fees, it varies from jurisdiction as to exactly which fees are included, but the plaintiff, if the plaintiff wins, gets to add those fees into the judgment against the defendant. Now, what if the defendant wins? Well, the defendant, even though the defendant wins, the defendant would be entitled to reimbursement from the losing plaintiff for these categories of out-of-pocket litigation expenses. They have to actually have been incurred. And so that's what court costs are. And the pleading of court costs in the prayer will be, for this reason, in both the plaintiff's complaint or petition and in the defendant's prayer in the answer, where the defendant prays that the judgment be 0 against the defendant, and also that the defendant recover the court costs that the law allows. And then finally, the fourth element here, all other relief to which Jones is entitled, is a catch-all statement. It is required under the Texas Rules of Civil Procedure, and that is the prayer, the direct request for the ultimate remedy that the plaintiff wants the court to impose against the defendant at the end of the day. Okay, now after the prayer, the attorney representing the plaintiff will have to sign this petition before it's filed. Now, if it's filed in traditional paper form, which is getting rarer, and we're going to look at this, but the old traditional way was that it would be printed out, and then the attorney would, with a pen, sign by hand this signature block. It's sometimes called a subscription because it normally appears sub or under the substance of the petition or complaint. And so this is a standard form signature block in Texas pleadings and other court documents. Respectfully submitted, comma, that's standard, and then the attorney signs, and it also has the attorney's bar number and law firm name and law firm contact information. And then you can see at the bottom in all capital letters, this identifies the party that this attorney represents. So this is the signature block. Now we'll look at an example a little bit later. If the petition or complaint is going to be electronically filed, then there will not be a hand signature. It will rather be typed in, depending on the local rules. Okay, well, that is an example of a petition. It just happens to be a Texas court petition. Well, once it's all ready to go, it's been finalized, and often paralegals help draft them, and the attorney will then look over it, make any edits or changes, and then it is ready for filing. Now, let me talk a little bit about filing, because paralegals often help with the filing process. Filing in litigation means submitting a document to a court clerk for inclusion in the court's official file relating to a particular lawsuit. Now, the court clerk is the court official responsible for maintaining the court's official records, processing filing requests, like people wanting to file petitions, answers, motions, and so forth. They also process payment of filing fees, and court clerks do a lot of other things. But for our purposes, that is the official to whom you would direct the petition for filing. Now, there are two main methods of filing. And as I mentioned a second ago, the traditional way has been on paper. That is, you the attorney hand signs the petition, and then that petition is then delivered some way to the court clerk's office, either by a hand delivery, mail, UPS, FedEx, whatever, but it's on paper. Now, that is becoming much rarer these days, because these days almost all courts require attorneys to electronically file documents. And so that means that you submit or you upload the document in PDF through the court's online filing system. And we'll talk a little bit more about that. So electronic filing is really almost universal now. But I do want you to know quickly how the traditional paper filing works, just in case. So to file a complaint or petition on paper, you would need to deliver to the court clerk's office. You don't send it to the judge directly, to the court clerk's office. And it's easy to find the contact information because the court clerk has a website. with a cover letter addressed to the clerk, and the cover letter will need to accompany the original petition signed by the attorney, plus at least one copy of it. And you may want to send 2 or 3. Some local rules will require a minimum number of copies to be submitted with the original. But the original historically has to be double hole punched at the top to accommodate the filing folders with the securing brads at the top that the courts typically have used. Also, if you're filing an original petition, then you would need to include the filing fee. Now, the filing fee will be easy to find out because you just go to the clerk's website and there'll be a link for the filing fee schedule. And the check would be made out. It'd be a firm check made out to the district clerk or the county clerk's office in question, and for the applicable amount. And then, unless you're going to personally deliver it by hand, let's say you're going to mail it or have it FedExed or sent by UPS, you would normally also include a self-addressed and stamped envelope addressed to your employer's law firm, so that the clerk can send the copies of the petition back to you once the clerk has processed the filing. So once the clerk gets this complaint or petition on paper, the clerk will file stamp it. That is with a machine usually that will stamp the date and time of filing. The court will process the filing fee, and then the clerk will assign a cause number to the case and will note that number either by hand or with a stamp in the captions of the original petition and the copies that were sent with it. And if you're in a jurisdiction where there are multiple district courts or county courts at law, the court clerk will also assign your case to a particular court and will fill in that blank on the captions as well. Now the clerk will then keep the original petition, the original paper petition, and then take the copies, and they will all be file stamped also, and put them in that self-addressed stamped envelope, and we'll just drop it in the mail and it'll go back to your firm. Now, if you do this personally, the clerk will just hand you back the copies. Or if you send a courier, you might hire the courier to come back to your firm to deliver the copies. So this is what if you file on paper, the top of the first page of the petition would look like, or approximately look like, once the clerk has gotten through processing the filing. So first of all, here is an example of a file stamp, and it indicates the date and time of filing with the clerk's office. Now again, this is a fictional petition, so this is not an actual file stamp, but they all resemble this to some degree. Then the clerk will have entered the actual cause number. So now you know what the cause number is. So you'll have to type that in on every caption and make sure that it is saved and typed in every caption for every document that you file from now on in the case. And also you can see here, the clerk will fill in the specific district court number if there are more than one district court in the county. And again, the clerk will fill all this information in on the original and on the copies that will go back to the firm. So that's the traditional paper way. But today, as I mentioned, electronic filing, also known as e-filing, is pretty much universal, at least with attorneys. If a party is represented by an attorney, then in most jurisdictions, at least in Texas and in the federal system, the attorney is going to have to file electronically. Now, some courts will make exceptions for parties that don't have attorneys. That we call them pro se parties because they're acting on their own behalf. They chose not to hire an attorney. Sometimes courts will allow those parties to still file on paper. But in any event, the e-filing or electronic filing process involves uploading the petition in searchable PDF using the appropriate online filing system for the court. Now, here are the online filing systems for the federal courts and for Texas. If you are filing an original complaint or any document in a federal court, you would have to file it electronically using what's called the CMECF system. It stands for Case Management / Electronic Case Files System. That is the system that all federal courts use for filing, and every federal court's website, every U.S. District Court's website will have a link to that filing system for that particular court. And so here's an example of a link. If you clicked on it, it would take you to the CMECF filing link for the U.S. District Court for the Northern District of Texas. But again, you just go to the court's website, federal court's website, and it'll have the link to the CMECF system for that court. Now, Texas courts now use the eFile Texas system, which you can find at efiletexas.gov. Now, it works a little bit differently from the CMECF system in the federal courts. In Texas, once you go to efiletexas.gov, you then select one of a number of certified electronic filing service providers. They have links and descriptions of all these different providers of filing services that have been certified to file through the efiletexas.gov system. And they all have different characteristics and they all have different features. And so your supervising attorney or law firm will probably already have a preference and already be signed up with one. So, but that's how you would do it when you're electronically filing in a Texas court. Now, only registered attorneys and any pro se parties, that is, who don't have attorneys, who have consented and registered to use the e-filing system can use it. Your attorney will have a unique user ID and password for uploading documents and filing documents in the case. Some member of the public can't just come along and start filing documents in your lawsuit. You have to have a password and a user ID. I mentioned that when you're e-filing, the documents have to be in searchable PDF, that is portable document format. And when I say searchable, I mean if you have a petition, you do not print it out, have your attorney sign it with ink, and then go scan it to PDF. Because if you do that, it's not searchable. So that's why if you e-file, the petition has to be such that the attorney's name is simply typed in the document on the word processing system where the signature would have been, and then you just convert that whole Word document directly to PDF, no scanning. That way it can be searchable. Now, another requirement for electronic filing is that if there's any confidential or private information, such as social security numbers, dates of birth, and so forth, they must first be redacted, that is, marked out from documents before they are uploaded into the filing system. You may have seen police reports or where certain information has been blacked out or whited out so that you can't see it because it's private or sensitive or whatever. It's the same concept here. It's just so that private information, especially information that is, like social security numbers, other information could be used to steal identities, is not going to be visible, because court documents, most of them are public record once they're filed. And so that's the importance of redaction. And if you do file online a lawsuit, then you have to pay the filing fee, and that normally will be done through just entering credit card information for the firm's credit card, or the firm may have an account with the service provider, which will bill the firm at a regular basis, but that would be how the fees would be handled there. Okay, so that is the filing process, either on paper or electronically, most likely electronically. Now, the last subject I want to address in this first part of the lecture is giving the defendant proper notice that the lawsuit's been filed. You've got the petition on file, you've paid the fee. Now it is time to effectuate service of process, which, as I mentioned earlier, is a copy of the plaintiff's complaint or petition, plus a document called a summons in federal court or a citation in Texas court, which are then delivered to the defendant, usually by hand, and thereby give the defendant proper notice of the lawsuit in accordance with the Due Process Clause of the United States Constitution. So, to set the stage for service of process, I want to give you a little bit of terminology here. First of all, the term service. In this context, service means formal delivery in a manner permitted by law. Now, the term process, and again, you kind of think of due process, but in the context of giving a defendant proper notice of a lawsuit, process here refers to the combination of two documents: a copy of the file stamped complaint or petition, and a separate document called a summons in federal court or a citation in Texas court. Now, the summons or citation will it's directly addressed to the defendant and tells the defendant has been sued, and that the defendant must file a written, either appear in court or file a written response to the lawsuit, and it will tell the defendant how to calculate the deadline for filing that response to avoid the entry of a default judgment against that defendant. And we'll look at briefly here what a default judgment is at the tail end of this lecture. So we have service and we have process. So when you put it together in this phrase, service of process is the formal delivery to a defendant in a manner permitted by law of a copy of the complaint or petition and the summons or citation, and thereby giving the defendant proper notice of the lawsuit. Now, let's talk about this summons or citation. Again, in federal court, it's called a summons. Well, how do you get that? In federal court, normally the plaintiff's attorney's office, and it could be a paralegal who does this, will prepare the summons form using a form or template that the court has approved. And then once it's all been filled out with the required information, then that will be submitted to the court clerk, who will then sign it and place the court clerk's seal on it. And then that makes the summons, quote unquote, issued, and now it's ready to be coupled with a copy of the complaint and delivered to the defendant. Whether it's a summons or citation, normally the information that you would have to insert into the form would be the name and address of the defendant, and the name and identity of the plaintiff's attorney, the appropriate information in the style, or I'm sorry, the caption of the case, who the parties are, the case number, and so forth. So again, in federal court, usually the plaintiff's attorney's office will prepare the citation and then just submit it to the clerk's office to quote unquote issue it by having a clerk or a deputy clerk sign it and seal it with the clerk's office seal. And then they'll usually return it to the plaintiff's attorney, who will then make sure that it gets delivered to the defendant. Now, in Texas lawsuits, it's handled a bit differently. The clerk's office itself prepares the citation. They just print it off using a computer program, and you have to pay a little fee for citation, and then the clerk's office will print it off and sign it and put the seal of the clerk's office on it, and then return it to the office of the plaintiff's attorney, who then will make sure it gets delivered on the defendant properly. So, but this is what is known as issuance of the summons or issuance of the citation. It becomes issued once the clerk has signed and sealed it. And that means it is now ready to be delivered to the defendant. Now, here's an example. This is the standard form Texas court citation, just so you can get a flavor. You can see here that there's a salutation. It is directed to the defendant, and it has the defendant's address, and then it says, ironically enough, "Greetings, you have been sued. You may employ an attorney." And now the citation explains how to calculate the deadline for filing the answer or other appropriate response with the court. Now, I'm going to just read it the way it's worded in this official form. In the next lecture, I'm going to explain how this works in practice. But it says, if you or your attorney do not file a written answer with the clerk who issued this citation by 10 o'clock a.m. of the Monday next, following the expiration of 20 days after you were served with this citation and petition, a default judgment may be taken against you. Okay, so to calculate the deadline, at least using the language here, is basically you have to work backwards to the date of service. 10 o'clock a.m. on a Monday, that follows the expiration of 20 days after you were served with the citation and the petition. And then the citation goes on to provide the identity of the court and the address of the clerk where the answer should be filed. Now, this is just part of the citation, but I wanted you to see this first paragraph especially, because it tells how to calculate the deadline, and it notifies the defendant you have been sued. Greetings. Now, what are the proper methods of serving or delivering suit papers to a defendant? When I say suit papers, I mean copy of the petition or complaint and the summons or citation. Well, if the defendant is a human as opposed to a corporation or some other entity, then the most common method of service is what we call personal service, and that is hand delivery of the suit papers to the defendant himself or herself personally. Now, if you're suing a corporation or an insurance company, for example, if the corporation or insurance company is authorized to do business in Texas, then there are, by law, other ways you can serve these entities, because to be authorized to do business in Texas, they have to designate what is called a registered agent for service of process. That is, someone in the state who, in the event that company is sued in the state, will be authorized and can receive the suit papers on behalf of the corporation or insurance company. So if you ever want to find out, well, who is this registered agent and where is that person's address, for corporations, you would go to the Texas Secretary of State website, and you would want to go to the corporations section, and then you can look up online for free the all corporations that are registered to do business or authorized to do business in Texas, and you'll find their registered agent information. With insurance companies, you can go to the Texas Department of Insurance's website and get the same information there. Now, on occasion, especially if the plaintiff's attorney tries and tries and tries to get a defendant served with process and is unsuccessful, the plaintiff's attorney may elect to file a motion with the court asking for some type of substituted service or alternative method. And the court will be pretty likely to do that, to allow this alternative method if there is evidence that the defendant is intentionally attempting to evade, that is, avoid being served with suit papers, such as if the process server goes up to the door of the defendant's residence, the defendant peeks out the front window and then slams the curtains or blinds and refuses to answer the door, that kind of thing. So the plaintiff's attorney may then file a motion and ask the court to authorize some other method. And one method for human defendants, anyway, that is commonly authorized by courts is to have the process server simply tape the suit papers to the front door of the defendant's residence. But again, to do that, though, you would need a court order authorizing it. You don't need a court order for personal service or sending certified mail to a corporation or insurance company's registered agent. But alternative methods, you do have to file a motion with the court and explain why you are needing it, and the court has to approve it. Okay, well, I just used the phrase process server. What is a process server? It's simply the person who formally delivers suit papers to a defendant. That is the person who accomplishes personal service of process. Now, it's pretty broad who is, by law, can be a process server. Generally, as long as the person is not a party to the lawsuit and is at least 18 years old, that person can be the one to deliver the suit papers to the defendant. And in fact, the plaintiff, it could be an employee of the plaintiff's attorney's office to deliver the suit papers. Because again, as long as the person is not a party to the suit, as a named party in the lawsuit, plaintiff or defendant, and is at least 18 years old, then it's fair game. Now, there are process servers, though, who charge to do this. And there are process serving services, businesses who are engaged in the business of doing this for a fee, and they're hired by plaintiffs' firms and so forth to do this. And some court reporting firms have people on staff who will serve suit papers or subpoenas and things like that. Now, in Texas court, you can pay a Texas constable to go out and serve the suit papers, and this constable would be in uniform, and so that's something that's very easy to do. And if you're in federal court, you can have a federal marshal serve the suit papers. So that for a fee, and so these are commonly used. You might have a plaintiff's law firm that has an employee that doesn't mind doing this. It can be an iffy situation. People don't usually react with gratitude and love when they receive suit papers, and you never quite know how someone's going to react. And so professional process servers or uniform constables or federal marshals are sometimes seen as a preferable alternative to sending someone from your law firm. Okay, well, once personal service has taken place, the process server then completes a form called a return of service. And this is like an affidavit. And it will, in this form, the process server will detail the date, the place, the method, and time of service, and then sign it. And once this form has been filled out by the process server, then usually the process server will give it to the plaintiff's attorney's office, which will then file it with the court, so the court will have a record of when the defendant was actually served. Now, service of process requirements generally will vary from jurisdiction to jurisdiction, in terms of what are the proper methods, who can do the serving, and so forth. And so you'll want to be sure that you double check the requirements of the specific state, or if you're in federal court, the federal rules that govern this, to make sure you are complying. Now, here's an example of a return of service form in Texas. And this would be, again, what the process server would fill out after completing the service of process. And so here, the first line, it says, came to hand on, and then there's blanks for a date. The process server is supposed to indicate the date on which the process server received the suit papers from the plaintiff's attorney's office for delivery. And then it says executed at, okay, now this is where the process server actually delivered the suit papers to the defendant. And there would be an address in the county name at the time, and so forth, and identifying to whom the papers were given, and that sort of detail. Notice also that there are blanks for the amount charged by the process server to the plaintiff's firm for these services. If the process server has charged for this, this would be evidence of service of process charges for court costs down the road. If the plaintiff wins the case, then these charges for service of process would be part of the out-of-pocket costs that the plaintiff would automatically be entitled to reimbursement from by the defendant. So that brings us now to formal notice, and now we are set up. The ball is now in the defendant's court. What will the defendant's response to this lawsuit be besides frustration, anger, and consternation? Well, that will be the subject of our next lecture. Thank you for listening.